podcast includes commentary and conversations about issues relevant to clinical psychology. It is intended to educate, entertain, and enlighten, and is not a substitute for actual mental health treatment. Individuals who share personally here choose willingly to tell their stories to benefit you, the listener. All other references to clinical situations are altered or limited to protect confidentiality. For more specific questions or help with a personal situation, please consult a local mental health professional. Therapy, mental health, real life. This is Psych Rally with Los Angeles-based clinical psychologist Dr. Martin Hsia.
All right, welcome back. Today we are on to episode 31 of Psych Rally, and we're switching gears a little bit to talk about a frequently thought of to be a difficult and unpleasant topic, but hopefully we'll, with my guest here, be getting some information that maybe can mitigate the unpleasantness of it or give us some ideas and ways to think about it from a legal perspective. And we're talking about divorce. And for anyone listening, there's a good chance that this may be something that personally you have experience with, and so the potential devastation of it is not a secret to you, and that can be across the board and in many forms. Many people may know that around 50% of marriages in the United States end in divorce, and that number is similarly high, to my knowledge, in many other developed nations. And when you break that down by the number of marriages, 41% of first marriages end in divorce, and that percentage rises progressively for second and third marriages. You can imagine the impact, if you're not aware, on both parties involved in a separation or divorce, the loss and the grief process of a significant, potentially very long-term relationship, of one's main source of companionship, someone who knows them very well, and just a significant, potentially best friend that someone may be losing. In worst cases, there may be a high level of hostility and just adversarial dynamics that can impact someone's life for years if the process is ongoing, and certainly may be very traumatic if there are unrevealed secrets, infidelity, financial things that are undisclosed that come out in the process of divorce. Those are all things people have to be dealing with. And again, research shows this, but it's probably pretty intuitive. Rates of depression, self-esteem, sense of identity can be adversely impacted by going through a divorce. There can be a stigma about it where people feel socially rejected or embarrassed having to go through a divorce. The alienation potentially from people in their lives who are non-approving. And, sometimes people, even though they're losing a significant person in their life, may also be losing the social support of family members, in-laws, friends who are close with an ex-spouse, and the resulting social isolation, not to mention the financial adjustments and pressure. We can just get the picture here. It's very overwhelming. What about kids? Yeah? Now, and regardless of age, the research shows the rates of anxiety, impulse control, behavioral things can very much be adversely affected for kids, teens going through a divorce. Academically can be impacted, you can imagine, and certainly self-esteem. And now children's psychological reaction to a parent's divorce can vary in degree depending on a number of factors, which we'll talk about some of that here too. But all this to say, from the perspective of someone who works with plenty of people dealing with all sorts of difficult issues, even in the context of intact marriages and families, it's very sad and difficult to imagine how painful a high conflict separation or divorce can really, shatter a whole system of lives, especially people who are underage and vulnerable. So, to help us kind of talk through this a little bit more and kind of make sense of this again from a legal perspective, explore this more, is my friend, family law attorney and mediator based here in Pasadena, Mark Baer. Mark is the co-author of the book, Putting Kids First in Divorce, How to Reduce Conflict, Preserve Relationships, and Protect Children During and After Divorce. I like that. That's a good thing. He's an avid blogger for Huffington Post and for years has been a regular contributor to the bi-monthly newsletter of our local psychological association and has been interviewed for a plethora of other articles, publications, media outlets, And I'm going to stroke your ego a little bit more, Mark, before I bring you on. A few other accolades just to, so you know who we're talking with. He was named top attorney by Pasadena Magazine for 5 consecutive years, was named a Southern California super lawyer for 3 consecutive years. He was included among the National Advocate's Top 100 Lawyers in 2014. And recently in 2015 was selected by the Corporate America Legal Elite as most compassionate family mediator in the state of California. We're very fortunate today to be talking with attorney and mediator Mark Baer. Mark, thanks for joining me.
Hello, thank you for having me.
My pleasure. What did I miss here? I kind of gave you a little introduction of kind of who you are, what you do, and what you've accomplished. Anything else to fill in the gaps so people know where you're coming from?
No, I'm not so concerned about what the awards are and things like that because they're subjective. So, some people might feel that they're deserved and some people might not, and I feel the same way towards other people, and I know people who don't have awards that I think should. So, so I think it's more about what somebody's actually doing and how they handle particular matters as opposed to awards they receive from people or organizations that they didn't even work with.
Sure. Well, and that very much off the bat reflects, I think, what I know of Mark's character and what we'll be talking about today. Before we talk about, from an attorney's perspective, the process of divorce and what you've seen and what you do, you've written before about how family law is basically like war. Like a military conflict. Can you say some more about that?
It's adversarial. Our system is designed as an adversarial system. War is adversarial. It's pitting one against the other. So, from a practical point of view, and I realize that a lot of people may not hire lawyers to represent them, they're still going to be in an adversarial system if they don't opt out of it. And an easy way of describing this for the when lawyers are involved, for example, would be the following. So let's say that I'm divorcing, and I go and hire a lawyer to represent me. The minute that I hire that attorney, I'm going to hire them because I have trust in them. I'm not going to hire somebody I don't trust.
Yeah.
I may lose that trust at some point, but I have that at that moment. The fact that I hire you as my attorney, for example, that's going to make my spouse or significant other feel less trusting toward you than they are toward me,
right.
Because you're hired as my advocate. So when my spouse goes and hires an attorney to represent them, it's going to be the same thing. So we've essentially, just by virtue of that and before anything else is done, we've increased the trust problems between the people. We've increased the level of conflict before
even doing anything
else
beyond that
is done.
Yeah.
If instead people go and they hire jointly one person, for example, a mediator, now you have them both signing up or both trusting that same person. They may not trust each other, they may not like each other, but the fact that they both trust that same person, you've now created a bridge as opposed to making things worse.
Symbolically, you've already set up the whole process very differently, right off the bat.
Exactly.
Yeah. Talking from a mental health perspective and from a family systems, thinking of kids and minors perspective, the whole war metaphor is probably not so compatible with preserving any of those factors, correct?
Exactly.
Yeah. You once said that in one of your articles, you said the ultimate goal should be to break the cycle of violence. As with military actions, handling a conflict through coercion does not actually resolve underlying conflict. This is from one of your articles. And can you expound upon that and how that plays out in the legal process?
Yeah, and before I do, I want to say that about a month and a half ago, I read an article, and it was the editor's column in the Los Angeles Lawyer magazine, and in it, and it's for lawyers, he was very clear that a lawyer's job is to take on their client, to fight their client's battles. So I want to be very clear that it doesn't matter what area of law we're talking about. If lawyers believe that their job is to fight their client's battles, first of all, if a client doesn't have a battle that they want fought, we have a problem.
Mm-hmm.
If they're in a battle and they want to get out of it, we have a problem.
So what you're saying is just built into the philosophy being preached for the whole profession, that's already problematic.
Correct.
Yes.
So they're operating from the perspective that, and they use the terminology that they are gladiators and warriors.
Sure.
That's what they believe themselves to be. People use terms to describe themselves and what they do, and they act in accordance with that terminology.
So not just by fulfilling a prophecy of what you see on TV and Law and Order and in the courtroom. This is being preached from within the ranks of the profession. This is who we are.
Yes,
Yes.
I do want to add to that, though, which is that I've given presentations to a number of groups of attorneys of various types in the same room, for example, and there's a repetition after repetition from the people in terms of what the public is seeking out. There's a portrayal of lawyers by the TV, movies, the type of things that they that journalists want from the lawyers when they interview them, that essentially portrays the lawyers as doing highly aggressive things. And so the public now thinks that that's what a lawyer is supposed to be. So whatever it is that the lawyer already would have done, if they're not aggressive enough in the eyes of their client, now they have a client problem. And the clients want them to be more aggressive very often than the lawyers even would normally be. And if they're not acting that way, then the clients think that they're not serving them well.
Is that something you've experienced in your own work?
I have had that on occasion, but not for a long time because of the type of reputation that I have.
Right.
It's not who would be seeking me out.
Right.
But it is very much a problem. And I was just talking to somebody who does intellectual property, which is like copyright, trademark, patent work. And he was saying that he's having a situation right now with that same problem. He has the other side is behaving badly, and his client doesn't feel that he's behaving badly enough. He needs to behave even worse. And he said, we don't feel that is helpful, and it's harmful in our opinion. And so unless he can get through to his client, there's going to be an end of that relationship likely.
So again, to reiterate, both by what is being trained and preached from places of authority within the legal profession, as well as by expectation from people who are retaining attorneys, it's reinforcing to take on the identity and behavior of a gladiator, bulldog, take no prisoners, sort of alpha jerk.
Yeah, and the other thing that was interesting was the intellectual property attorney that I was mentioning. He's told me for years that he really likes my approach and that he's been wanting to refer people to me, but every single time somebody approaches him for a referral to a family law attorney, they always specifically ask for a very aggressive family law attorney. And again, so I said to him over breakfast last week, I said, so let me see if I understand this correctly. You're telling your own client that you shouldn't behave that way even though they think you should, because the other side is. And yet when somebody comes to you for a referral for a family law matter, you refer them to somebody who's behaving like the opposing counsel on your case, which you don't find helpful. And I'm trying to understand why you perspective take with your own client and explain or cause them to question whether that's a good approach. But when they come to you for a referral for a family law matter, you give them what they think that they want without doing the same perspective taking.
Right. Where's the professional integrity there?
Exactly.
Now, there's an alternative to the traditional, what we see on TV, the high conflict litigated divorce. And by the way, I read somewhere that the average cost of a litigated divorce in California can be $45,000 per side, so $90,000 altogether, versus the average cost of a collaborative divorce or a mediated divorce is significantly less. Talk about collaborative divorce first as a alternative to a litigated divorce. What does that mean for the layperson, and how does that look?
Before I do,
Please.
Those figures are for the entire state of California. They're a couple of years old. And in my mediation study group, where we have people who are still litigating that are in it too, somebody just a couple of months ago asked the litigators what they thought that the average cost of a fully litigated divorce is in the state of California. Mm-hmm. It's nowhere near that.
Really?
We're talking several $100,000.
So this is a gross underestimate, actually.
Correct.
Wow.
Yeah.
That's frightening.
Yeah.
To think of.
Yeah. So
okay.
So anyway, but with regard, you asked me about collaborative divorce?
Yes.
So collaborative divorce is a particular process and approach. It's essentially where, among other things, the lawyers, the clients and the lawyers sign a participation agreement in which the lawyers say that if the matter falls out of this collaborative process, they won't represent these clients in an adversarial divorce. So they're agreeing not to handle it in a litigated manner, which is the war that we were talking about. And it's technically interdisciplinary in the sense that you have other people on the team in addition to those lawyers, or you can or should. Those might be mental health professionals who are not acting as therapists but are helping to work with the clients on communication issues and de-escalating conflict and other such things. You have a neutral financial person who's helping to deal with the number issues.
Mm-hmm.
I think the reality is that it's important to understand that just because somebody goes to law school does not make them psychologically minded, doesn't make them, and in fact I'd say that it's quite the opposite. It doesn't make them experts with regard to numbers.
Right.
In fact, most attorneys, unless they go into intellectual property or tax law, typically ran away from that
Not
type
number
of thing.
savvy, yeah.
Yeah. And so the reality is that bringing on an interdisciplinary team of professionals, in theory, can be useful because you're in theory essentially bringing on people more appropriate for different aspects of the divorce.
And theoretically, if both parties in a divorce process agree to bring in these interdisciplinary professionals, there's the suggestion, at least, or the intention of some level of collaboration, of facilitating the process.
Yes, and they would have to agree on that if it's in the collaborative process anyway. It's not like one could bring it on and then the other not. I make a distinction between a collaborative divorce, which is a name of a process,
Mm-hmm.
and collaboration.
Okay.
You know, I might look at a collaborative divorce case and say that if it's able to be completed successfully, that chances are it's going to be a more optimal resolution than if it were litigated. But that doesn't mean, in my understanding of collaboration, that the process was in fact collaborative. It might be cooperative. Collaborative is a subcategory of cooperative. I think it could be cooperative and be a successful collaboration in a collaborative divorce.
Fair enough. No, I caught when you sort of said, in theory, this is how it should work, or this is what it should mean. And, if I'm assuming if all goes according to plan along that theory, it's maybe it can be a better alternative to a full-on non-collaborative at all divorce.
Yes, I think that, look, I think that when you have, first of all, just because I wrote an article a number of years ago, and the executive director for the International Academy of Collaborative Professionals called me the next day. And I thought I was in trouble for having published that article and that I was going to get an earful. It's not what happened. She essentially said that if she wanted her dog to become a member of the International Academy of Collaborative Professionals, that the dog could. So in other words,
assuming he could pay his dues online,
and she would pay it for him.
Okay.
So so being a member of an organization, going to a 3-day training does not make you something.
Mm-hmm.
So the reality is, as with anything, there's different degrees.
Sure.
And there isn't even any sort of testing or anything to see if these people, what their skill set is.
Right.
So from a practical point of view, what happens if both of the attorneys that are selected aren't in fact very collaborative? What happens if one isn't in fact collaborative? What happens there? And then you have what happens if there's personality conflicts between the professionals?
I can't imagine that happens often.
Yeah. So it's really important that the right team be put together. And one of the problems with collaborative divorce, and one of the reasons why it doesn't seem to be growing in California, is that the same teams keep getting comprised over and over and over again. So therefore, outsiders don't get to be part of that team.
Interesting. And
different teams might be better for different situations. So using the same teams over and over again isn't necessarily great, in my opinion.
Gotcha. So some good intentions there, but in practice, there's a lot of barriers that in reality doesn't always deliver on the promise. That's what you've seen?
Right.
Gotcha. Okay. And now mediation, taking it to another degree.
Mediation is a vague term. It means different things to different people. So it's somewhat problematic in that end. It's completely unregulated. But then again, so is collaborative divorce, at least in some states like California. But so the question is, what does mediation mean? Like, for example, in the legal profession, the lawyers tend to view mediation as a retired judge who likely never got any training in mediation, sat on the bench for whatever period of time in that particular field of practice, and retires from the bench and says they do private judging, arbitration, and mediation. Now, it's true that when I used to litigate, that these same judges would do mandatory settlement conferences, for example. They're essentially treating the mediation as a settlement conference. And what that means is that it's all about what that judge thinks would happen if the matter goes to trial or goes to a hearing or whatever. And there's a lot of problems with that from my perspective. Number one, it's creating a buy-in for a win-lose. And the
still zero-sum game.
Right, and the adversarial process is about win-lose, and when families are involved in a win-lose, oftentimes what happens is you have a lose-lose. So it's creating a buy-in for a win-lose or lose-lose dynamic. It's not going to be a win-win dynamic in that kind of a thing, because the law is about, here's who was on the side of the law in this particular thing that may end up being better off, in my opinion, and who's going to be worse off. But the other reality is that if the exact same case were to go in front of any number of judges, the results would never be identical. So when I used to litigate, even before I got trained in mediation, if I could, I would try and get the judge that was going to be the judge trying the case, if it went to trial, to be the one that would do the settlement conference, because that judge's mindset, biases, beliefs, assumptions, values, expectations would be the one who would be assessing who they believe, how they weigh the evidence, how they use judicial discretion, all the other types of information. So, if they're the ones who were doing the trial setting, the settlement conference, then I have a pretty good idea of where that thing's going to go if it goes to trial. If I have a judge doing that who's not going to be the one who's doing the trial, then that judge is pretending that they have a crystal ball that works, and the reality is that that's smoke and mirrors.
All of which feels and sounds so far removed from what's in the ultimate best interest of the parties involved, and let alone the minors involved. Yeah.
And the other thing is that because they have no legal mediation training, among other things, and the way that they're doing it, they do what's called shuttle or caucusing mediation, where the party A is in one room and party B is in one room, and the mediator is shuttling back and forth. Well, that's not, first of all, that's not really helpful, for example, if the people have kids together that are minor, because they're going to have to be able to communicate with each other, one would think, after this is done. But you're not helping them to problem solve.
Right.
So there are a lot of issues with regard to that. And also there's research to show that in family law matters, when you do that kind of stuff, that type of approach, among other things, if there's ongoing jurisdiction, and what I mean by that is, if I have a personal injury accident, like I'm in a car accident and I file a lawsuit, once that case is settled, or once that case is resolved in court, I can't go back in later and ask for it to be revisited. I mean, if I feel that there's basis for it to be appealed, then I might do that. But I can't, but in family law, if you have minor children, the court retains jurisdiction over that, because while you have a certain parenting plan and such in place, that might change for whatever reasons, based upon change of circumstances or whatever, while that child or those children are still minors. Same with child support, same with spousal support.
Right.
So the thing is that the research shows that when you do the win-lose, when you do shuttle mediation, you have a much higher chance that this couple will be back in court within 12 to 18 months, for example.
All of which just vicariously sounds exhausting and very painful.
Yeah.
Right? I mean, I think other research findings are very clear on the how prolonged a divorce process is, not to mention the level of conflict also correlates with the level of adverse emotional consequences for all involved.
Yeah, and the other thing is that when lawyers are involved, the lawyers are the ones that are picking the mediator. So the lawyers pick the retired judge mediator, but I said at the very beginning of this program that if both spouses or all parties hire the same person because they, for their different reasons, both or all trust that same individual, then that person's a bridge. How's that happening if the people who picked them were the lawyers and the clients themselves never even met that person until they walk in for the mediation?
Right.
So that's one type of mediation.
I see.
Another type of mediation would be facilitative, where the where the mediator is acting as a facilitator and helping to facilitate problem solving by the parties. So they're helping the parties to, and this is assuming that facilitative mediator is well trained and well skilled. They're going to be using their skills to help to de-escalate the conflict. They're going to be helping to improve communication. They're going to be helping to elicit understanding, because most conflict in the world stems from poor communication, misunderstanding, and things like that. So if you know something,
That's the truth.
yeah. So if you know something that the other party doesn't know, and you think the other party knows, or they're not hearing you properly, or they're not understanding you properly, or there's just some missing pieces, that mediator can help to elicit that so that we have the understanding. If people can't make decisions oftentimes if they feel as though they're not properly informed. Why would you want to make a decision? Why would you want to make an agreement if you feel as though you're missing information or knowledge that you need to have in order to make that decision or agreement? So the mediator is helping to elicit that information, and it may be that some of the information they may help you elicit is possibly to bring in some expert to help get certain data that they need, but they're both hiring that person, for example, as opposed to two bringing on different experts who are fighting against each other.
What you're reminding me of is something else you wrote about, which is the difference between a dispute and a conflict, and how, semantics, I suppose, but we call a dispute more about facts, and conflicts can be much more colored by emotion. And so often when working with couples in a therapy practice, or even just working with one member of a significant relationship, it's so easy to get caught up on facts, which in the court of law, in some ways, that's what gets debated. But in a couple's, if a couple is really trying to work on their relationship and improve things in a collaborative way, the facts are in some ways very secondary. Was the toilet seat left up or not? How many times? How often does it happen? It's less important than what something symbolizes and the meaning that each partner attaches to it. So it's a very different. And I think in some ways in mediation you kind of have to get more at that than someone who's in a litigating mindset is not interested in that at all.
Well, a fact might be maybe there's a business that one of the spouses owns and it's not going to be sold, but one of them is going to be buying the other one out possibly, or one of them is going to be buying out the other person's interest in the house or something like that, and they don't agree on what the value of the business is, or they don't agree on what the value of the house is. Those facts are not secondary. Those facts are
Fair
primary.
enough.
But the question then becomes, how do we assess what the facts are?
Sure.
Do we each bring on different gun for hire experts who are going to be valuing the business either high or low depending upon whether they're representing the spouse who's planning on buying the business or who's planning on being bought out, and then having a judge decide which of those experts' opinions are more accurate, or split the monkey somewhere? Or are we going to sit down and elicit the information, maybe agree on a third on one individual to go and do the valuation that we both trust and use that figure? So when I talk about working together, that doesn't mean that people need to be amicable. That is a terrible.
That doesn't mean that they will be amicable.
That's a terrible
right?
fallacy. It's
Sure.
not. It's completely untrue. You don't have to be amicable to be to be agreeing upon mechanisms to deal with things upon which you don't agree.
Sure.
So that you can gather the information to reach the agreements that you aren't able to make right now.
And what's a completely different goal than a couple in an office like mine, where presumably the goal is to preserve and build the health of a relationship. So that makes sense. Not everything is going to be amicable by any means. Now, something else that you once wrote and we've talked about, which is the belief that you have that all individuals going through a divorce process should receive some form of psychological care. There's a lot going on. Say more about that.
First of all, there's, as you said at the very outset, there's a lot of psychological stuff going on when people's marriages end. And the level of loss associated as a result is extremely high. It's the highest level of loss that somebody could experience absent the death of their child, unless maybe it was an abusive spouse or something like this. And the thing that causes divorces to go, or I'm going to be more broad than that, breakups, because it could be non-marital with kids, breakups to get contentious is what's known as unprocessed emotions.
I've never heard of that. Yeah,
so if your emotions aren't processed, there's going to be an issue here. If I'm if one parent is thinking that they think of the child in terms of being mine, and I'm not talking about going and using that term where it's appropriate because you're saying to somebody, this is my son or this is my daughter. I'm talking about in relation to the other parent, regardless of what words you use. If in your head that other parent's really not the same level parent, isn't really a parent, they're more like a sperm donor as far as you're concerned, you're going to treat them that way because that's how you feel. And this is going to impact the co-parenting relationship. It's going to impact the child because chronic parental conflict is what has been found to traumatize children. And it is not the divorce or separation. It is the chronic conflict. And when it's related to the child-related issues, it's even worse for the kids. And so when you have these unprocessed emotions, for whatever reason, we have a problem here.
So I think, Mark, you're making a case, not just in what we're talking about today, but from so many things I know about you and what you're passionate about, for two things. Primarily a critique of the philosophy embedded in the legal profession and how that adversely impacts something like divorce. But beyond that, in this case, that divorce does not have to be this horrible all-out warfare thing that should be avoided at all costs, right? I mean, if it's mediated, if it's we'll say cooperative, not necessarily amicable, but there are alternatives to a dog-eat-dog zero-sum game litigative process, if that's a word. If people knew that, perhaps that could be a possible better way out of prolonged horrible conflict, kids sleeping out in the backyard, one kid is mine, the other kid's yours, property mentality, and the adverse effects on all parties involved.
Yes, and the other thing I'd like to add, if I may,
please,
is that we already spoke about the distinction between a dispute and a conflict, in my opinion, which is a dispute is fact-based, a conflict is emotional. There are people who don't have any factual dispute with each other, and the issue is entirely emotional.
I think that happens a lot.
It may be, whether it's in family law or not, and it may be that it's just not something that the court has the ability to resolve. There may be a dispute, for example, between parents who are no longer together in terms of to what extent, if any, either of them is going to pay some, if not all, of the child's college education. No legal obligation in the state of California to do that unless you somehow bound yourself to do that in a divorce agreement of some sort. If one of them is trying to get the other one to come up to bat, that is not a factual dispute because you can't go in front of a judge and force it. It's not a legally factual dispute. There may be a dispute between the two of you. Maybe there was a dispute in terms of what was agreed to informally at some point, and you're viewing it as a factual dispute. It is not legally binding, and therefore it is not, in my mind, a factual dispute.
It's a conflict.
So if you go and you bring on a lawyer to try and get the other side to cough up money. You are now making it less likely that the other side is going to cough up money because they have no obligation and you can't enforce it. And you're now bringing in a nasty person to try and get the other person to come to plate voluntarily. Then, you know, and the other thing is, I think it's important for people to understand that if when you're dealing with a dispute, if you care about something, it's going to be emotional.
Sure.
So whenever you have a factual dispute, if it's something that you care about, it's going to have an emotional component.
Yeah.
When you are dealing with it, are you exacerbating the emotional component or are you de-escalating the emotional component? And if you have an emotional conflict, I'm going to say that, in my opinion, it requires emotional intelligence to help to deal with an emotional conflict. It requires psychological mindedness.
Yeah.
Well, you know, while lawyers may not like to hear it, there are certain things that they are in general better at or have higher levels of than the general public. And then there are things that they have less of. It is well known, time and time again, research after research, that they have, generally speaking, above average IQ. They have below average emotional intelligence.
Or EQ.
So when you're talking about conflicts and you're asking lawyers to deal with the conflicts, you're asking people who have less than the average level of emotional intelligence to help you deal with an emotional issue. It's important to understand that they're also known to be more emotionally disconnected, and so which explains in part why they have more than twice the level of substance abuse and other problems to the general public, doctors, and everyone else. And so
that's why there's the other bar, right?
Yeah. So you're asking people, and so in fact, it's more than 20%. So if you, based upon my understanding, if there are, and lawyers and judges count in that too. So if you have 3 lawyers involved in a case, chances are at least one of them has a substance problem or depression or something, and
is not dealing with it in a very good way.
And I'm going to refer to the judge as one of them. So so understand that reality.
So I think another thread that I'm hearing what you're talking about, Mark, and then we'll transition to some take-home messages here, is that ultimately, if a couple is deciding to go separate ways, there may not necessarily be an easy way to do that without intense emotion and high conflict. But for a lot of people, both from the professional perspective and from one's own marriage perspective, there are guaranteed ways to make that worse. And then there are options to move towards the ultimately agreed upon goal of separation of marriage and assets, etc., in a way that does not have to be hell on earth.
Exactly.
Yeah. What would be sort of some main take-home messages that you would have on this topic for colleagues in the legal profession?
For colleagues in the legal profession?
Yeah.
Well, I mean, but now we're talking about more than family law colleagues, which is fine. I think that it's regardless of what your area of law is, I think that there's a difference between possibly how a case is handled when you don't have some sort of ongoing ties with the people for whatever reason when it's finished than you do when you do have ongoing ties when it's finished. People are tied together for life through their children.
Right.
I don't care if their children are adults. They are tied together for life with those children. When people are involved in probate-related matters, where there's some sort of, where a parent, for example, died and there's an estate-related issue, it's again typically family related.
Yep.
So these people are tied together through their family. This should not, in my mind, be handled in the same way that you would handle a personal injury case with two people who aren't friends, don't know each other, etc. If it should be, there's the similarity that I'll make is, I've spoken with enough lawyers over the years that don't do family law, and somebody was telling me, when I'm dealing with an employment related matter, because this is an employment lawyer, I handle it differently. I put my warrior hat on. But if it's a family business, I take that warrior hat off. And the problem that I have, I think that that's right. But it's interesting that when I see lawyers in the family law lawyers in the Los Angeles family law community on the listserv for the Los Angeles County Bar Association, referring to themselves as warriors and gladiators. When I go to programs and they're referring to themselves as warriors and gladiators, this is when the employment lawyer would be taking off his or her warrior hat. Why is it that warrior hat is always on by lawyers who are in that field dealing with families? That there's something amiss here.
Right. That's the default. Rather than put it on, it's already on. We got to take it off.
Yeah, and the other thing is that I gave a program a number of years ago, and it was I essentially said to them, if you are in a matter where there's a dispute on something relating to the children, and your client can't agree with the other party, does that mean that the other party is unfit? And there was silence in the room, and finally somebody raised their hand and said, no, of course, I mean, they could be, but no, of course it doesn't mean that they're unfit. So then I said, assuming that fitness is not the issue, do any of you ever have your clients say anything like, the other parent is a good parent, has good parenting skills, the kids love them. This is not about that. This is about the timeshare schedule or whatever it may be. Everybody can always use improvement. Nobody's perfect, so we can all on anything use improvement. But, do you ever say anything positive? And I want to tell you that the first question was from somebody who is a trained mediator and collaborative law practitioner, and asked a question that I get asked every time I ask that question, which was, well, what about if they're unfit? And I said, but assuming they're not unfit. And the issue here is, again, emotional intelligence, because an aspect of that is deep listening. And if they didn't hear that I said, assuming that unfitness isn't an issue.
The first thing you said.
Yeah.
Right.
So then everyone in the room said, oh, we can't do what you're suggesting because we're supposed to be advocates for our client. And I said, but you just said that fitness isn't the issue. Yeah. How is it that you're not being an advocate if you recognize that the other parent has good parenting skills or that the children love them or whatever, and it's relating to a schedule, timeshare, whatever? And they said, no, we can't do that. We're advocates. And I know that was on a Thursday evening because on Saturday morning following that, I was at my annual update program that I mentioned that I go to in February. And I saw a judge, a family law judge, who used to be in one of my study groups before she became a judge. And she had been a mediator and a collaborative law practitioner, and I was telling her over lunch about this. And she says, before I became a judge, and after I had been doing collaborative divorce and mediation for a while, and I was still litigating, I started doing what you were suggesting. And I found that when I started doing that, more of my cases settled. Because the other party is seeing themselves through your eyes. And so if they're seeing all negative, then the assumption that they're that they're getting is that you are essentially saying that they're not fit.
Gotcha.
And she said, but now, as a judge, looking at it from the other side of the bench, so to speak, she said, almost never have I seen anybody do what you're suggesting. And she says, from my perspective as a judge, when they don't do that, they are each implying that the other is unfit. She says it is absolutely impossible that every single parent on every single case on both sides that come into my courtroom is unfit, whether they say it or not, just by reading the paperwork.
Right.
And she says, so from my perspective, when they don't do that, they lose credibility. So my question is this. If lawyers think that they can't do that because they're supposed to be advocates and doing that is going to somehow impair their advocacy, understand what that means. What it means is that they're increasing the likelihood it's going to go to court because they've decreased the likelihood that it's going to settle. And when it goes to court, they've helped to cause their client to lose credibility in front of the person who's supposed to make a decision. So, and if
you're not winning in any direction there.
So how is that good lawyering?
Yeah.
Now, if most people, because I already said, if very few people do that, and you happen to be one of the few people that do that, and the other side didn't, who's going to have more credibility in front of the judge when the judge has to make a decision?
And I bet you've seen that happen.
Yeah.
So, you're a salmon swimming upstream, suggesting a paradigm shift in the legal profession, but making a strong case. What take-home messages might you have, Mark, on this subject for people in my profession, mental health professionals, therapists, psychologists, people who might collaborate with attorneys or refer to, be working with couples, going through a divorce, post-divorce?
I've found, and it's not just me, by the way. It's been commonly discussed in mediation study groups and collaborative law study groups that there seems to, in general, be a disconnect with the psychological or mental health field and mediation and collaboration. There's a lot of belief that in order to protect their client, they need to get them into an aggressive lawyer. So the only thing is that I would say that the research is increasingly showing that litigation is actually a form of violence. And
I could see that.
I published an article on that in St. Gabriel Valley Psychological Association years ago, and have written a number of things about it. And I'm increasingly seeing it being written about. And in some of the books where it's being discussed, I'm pleased to see that my stuff has been referenced in that. But it is a form of violence. So if you're working with people and you're helping them psychologically, then how is it helpful to put them into a process where even the slightest amount of litigation can undo the benefit that the best therapy accomplishes?
You can make a strong case that it's harmful actively and in turn unethical.
Yeah, so I've come to the conclusion that either people are going to understand what I'm saying, or they're going to disagree. If they're I don't have a problem with people disagreeing. What I do have a problem with is people who are not going to question their assumptions, their biases, beliefs,
sure,
their expectations and things of this nature. And if they're not going to check those, then we have a bit of a problem, especially in the mental health field.
Hear that, colleagues? And any take-home messages, Mark, for the non-psychologist, non-mental health, non-legal professional person listening who is married or in a significant relationship and has contemplated divorce or been part of a family that went through divorce?
Well,
wise words.
I would like to say that mediation, facilitative mediation, for example, it's a conflict resolution process or conflict management, because not all conflicts. There's been research by world-renowned relationship expert John Gottman that the majority of conflicts that occur in marriage are in fact not resolvable, and that's even in really long-term good marriages. That doesn't mean that they can't be in happy and healthy long-term marriages. It means that they have to learn to manage them properly. Sure. And so people who are having marital problems, they can go to marital mediation, just as they can go. It's different than marriage counseling, for example. It may be that they come to realize in marital mediation that they might benefit from marriage counseling. One of the things that I've come to know is that people generally wait until it's at least 6 years too late to start marriage counseling, and you have a lot of water under the bridge. But maybe whatever issues there are, stigmas with marriage counseling, maybe marital mediation has less of a stigma.
I hadn't thought of that.
So, I've met a lot of people over the years that say, I don't need to understand any of this stuff because I'm in a happy marriage and I'm not in a field that touches upon this or whatever. And the reality is that we all have family members or friends or colleagues, and there's a lot of bad information going out. And if we're not going to be interested enough to know about this kind of stuff, to be able to provide the kind of guidance and information that our family members, our friends, our coworkers, our colleagues can benefit from, then they're just going to get potentially bad information. And if somebody goes and consults with a lawyer, for example, understand that and again, I'm not criticizing the attorneys, but the attorneys don't have an obligation in the state of California to provide their clients with non-litigation approaches to resolving something. And if they don't mediate and if they don't collaborate, then why on earth, when they have somebody sitting in their office who potentially would hire them, why would they be telling them about processes that the client might actually want and then not work with them? And so this is an important reality. And even if they are required to provide this information under the law of certain states, understand that we can convey information in a way that's going to cause people to be more or less inclined to follow our recommendation or take that information to heart. So if a lawyer is required, which they're not in California, to provide alternatives and they don't do the alternatives, they'll just convey it in a way that will cause you not to take it.
Wow. A lot to think about. Well, thanks for enlightening me and everyone listening, Mark. He's Mark Baer, family law attorney and mediator and writer and speaker, and on a mission to help us be aware and think through how else couples can handle the divorce process legally and psychologically and in ways that minimize harm. And I'm all for that.
Thank you. I enjoyed being on your show and interviewed by you. Thank
Pleasure,
you.
Mark. Yes. All right. Thanks. Well, I don't know about you, but I hope I never have to go through a divorce for many reasons. But I'm sure everyone who's been married before has said the same thing, and obviously in many cases it didn't play out that way. So probably the first follow-up thought to this conversation with Mark should be that if you care for your spouse and value your marriage, prioritize it. We got to maintain it like a home or a car or your health, whatever that may mean, and whatever that looks like concretely. But when there's a larger issue that pops up that's harder to resolve, dragging our feet on seeking relationship counseling or marital therapy is not a good idea. Yeah, if we wait too long and hope for things to get better on their own, you might just be waiting too long until not much can be done. Now, if things are not able to be salvaged, I think Mark makes a really strong case for mediation, and why sort of the conflictual lawyering up that we see in the media isn't the only way to go about it. And that in and itself may already be new information for people, but hopefully we can see the reasons why it's a better option. But in fact, it really sounds like adversarial litigation should be a last resort, if at all, because not much about the system, according to Mark, nor the training and the experiences of judges and litigators in the family law system, none of it is set up to minimize what's already a very painful process of divorce, and as well as the potential impact to both parties and any children involved. So that sounds like that should be avoided at all costs. I really respect how Mark talked so passionately about his opinions here. I think it's very evident to me that he wants to protect the best interests of his clients, but he knows that doesn't have to mean destroying everyone else in his path in a warriors and gladiators kind of way. Serving the best interests of his clients as an attorney and mediator is certainly compatible with facilitating communication and compromise, and I think that's understandably and clearly much more protective of healthy relationships and co-parenting, and just more amenable to preserving thriving and emotional health post-divorce. I think there's also a very interesting critique he makes about the legal profession and the culture of law. And, I'd be curious for others listening if you've had similar experiences and similar perspectives about the mentality into which you are trained as an attorney, or if you have attorneys close to you, friends, family members. And I'm sure that varies based on setting and type of law practice, but really 2 times the rate of substance abuse. Yikes. And no, I know, to be fair, I know that attorneys do lots of different things. It's not always just bulldog litigation as we see on TV. Sometimes it's, less glamorous, less in the spotlight, handling contracts, transactions, reviewing documents. And there are definitely people who are drawn to law to do things that are very meaningful to them, like immigration or advocating for justice causes, children in the foster system, public defense. But to the extent that the warrior and gladiator mentality pervades the water of legal training and legal associations, I'd be interested to hear and see how those in the profession cope effectively with that culture and how they maintain balance for themselves in what can be a very stress and anxiety-inducing environment. So, more information about our guest today can be found at his website. That's markbaeresque.com, Mark Baer, B-A-E-R, Esque as in Esquire, E-S-Q.com, or at the show notes for today's episode at psychrallypodcast.com/E/32. As always, I welcome any feedback or reactions via email at martin@psychrallypodcast.com. Certainly appreciate your listenership. Thank you for tuning in to this episode of Psych Rally.